he's ready.
No, I know.
So when the judge is ready, just knock so I can go into.
Yes, they are.
Already.
All rise. Appeal in the matter of Strategic Technologies Pty Limited and Procurement Bureau of the Republic of China, Ministry of National Defence.
Mr. Romsey.
May it please your Lordship, Your Ladyship. I appear with Miss Clarissa Jones of Counsel for the appellant, and Mr. Hashim Reza appears for the respondent. As the court will know, this is an appeal against the order of Mrs. Justice Carr, as she then was, dated the 21st of February of this year, by which she dismissed my client's challenge for the registration under Section 9 of the Administration of Justice Act 1920 of a judgment of the Cayman Islands Court dated the 25th of June 2009. And your Lordships will have, and Ladyship will have the references. The order itself is at tab 7 of the court bundle. The order of the Cayman Island Court is in the supplementary bundle, tab 22, page 124. And Mrs. Justice Carr's judgment is in the core bundle, tab 9, page 82. By way of preliminaries, as the court will appreciate, we will be considering in this appeal what I would call three-court situation. The true, as we would put it, quotes, original court, which delivered the judgment on the merits. In this case, the Singapore court. It was a default judgment, but it qualifies as a judgment on the merits. We don't dispute that. Or for that matter, although it doesn't apply to the facts of this case, the arbitral tribunal, which issued an award on the merits, and we'll look at the arbitration provisions of the 1920 Act in due course. So that's the first court. The second is what I'm going to call the intermediate court. My friend, of course, says that that counts as the original court for the purposes of the 1920 Act, and we don't agree with him about that. But I'm going to call it the intermediate court, in which the original judgment, in this case the Singapore judgment, was enforced or sought to be enforced by action, and it could as well apply to enforcement in some foreign jurisdiction by registration as well, or some equivalent process for that matter. And the third court we need to keep an eye on is the English court, the registering court, in which the judgment creditor seeks to enforce either what we say is the original judgment, or, as has happened in this case, the intermediate judgment, whether by registration or by common law action on the judgment. Your Lord, the court will be aware of what the basic battle lines are in this case. In favour of Mr. Reza's, the respondent's construction, he relies on the definition of judgment as any judgment, in Section 12 of the 1920 Act, the fact that the Act does not itself exclude judgments on judgments, and he also relies, to some extent, but we'll hear from him more about this in due course, on the non-amendment of the 1920 Act when Parliament did amend the 1933 Act in 1982. And he also, I think, relies on a supporting decision on similar language of the Hong Kong High Court in the Morgan Stanley and Pilot Lead or Pilot-led investments case, which is, if correct, essentially supportive of his position. And of course, he relies on the judge's conclusion in the present case. On our side, we point to what we do say is a significant body of commentary by academics and in textbooks to the effect that both the common law and the 1920 Act, and for that matter the 1933 Act as well, even before the 1982 amendment, which made the point explicit, we say that significantly supports the proposition that neither the common law nor the 1920 Act and nor the 1933 Act extends to judgments on judgments. And as prime backup for that, we refer to the case of Nuvian and Freeman, which we'll have to look at in due course. The judgment to be enforced must, we say, be final and conclusive on the merits. And by on the merits, we mean the merits in the original cause of action. From there, I wanted to make 4 general points. And the first is this. This point, the extent, the scope of the 1920 Act was, it is entirely fair to say, one of a large number of points before Mrs. Justice Carr. And you can see that simply from looking at paragraph 45 of her judgment and following, in which she lists a very large number of matters that she had to decide. And I wasn't there, but I'm not sure I know how long the hearing itself was, but it was 3 or 4 days perhaps, and there was an awful lot to get through. We necessarily say that the judge got the answer wrong, but it is also fair to say that if she made an error on one out of so many points, it may be said to be understandable, given the plethora of points that were before her. The second point is this, because it still seems to bubble up, if that's the right expression, in my friend's submissions. We do not, and since the refusal of permission to appeal cannot, dispute the competence and jurisdiction, to the extent that those terms matter and are relevant to today's appeal, of the Cayman Island Court to give the judgment that it in fact gave, the default judgment for the debt in question. The third point is this. Much of the language of both the 1920 Act and the unamended 1933 Act, taken alone, can, as a matter of language, fit a judgment on a judgment. Whether it in fact does so is a matter of looking at the Act, and we will look at both Acts as a whole, and looking at and considering other aids to construction. And I just put this thought in the court's mind. In examining the language of both the 1920 Act and the 1933 Act, the question is as much about the construction and meaning of the term original court as it is of the term judgment. And I will be showing your lordships and ladyships certain provisions, not perhaps the main provisions in either Act, but which provide strong indications, at any rate we submit, that neither Act can have been intended to encompass judgments on judgments, or at any rate they point very strongly towards that conclusion. Then, last, by way of introduction, I wanted to say this. There will be three themes running through our submissions. The first is that both acts, the 1920 Act and the 1933 Act, were based on and designed to follow the common law. The second point is that the common law did not and does not allow for the enforcement of judgments on judgments, essentially because they are not judgments on the merits. And as I said earlier, we'll be referring on that point to the Nuvian and Freeman case. And thirdly, and this is fundamental to the question of whether the purposive construction which Mr. Reza advocates to the effect that, well, he says a purposive construction cannot go as far as essentially to rewrite a statute. We will say, and I'll take you to one or two passages of Benyon, that in fact the meaning that we attach to the Act is entirely available and the preferable one simply as a matter of language. But if we have to, we'll be saying that this is one of those cases in which a strained construction of the language is appropriate. And the central point is this. We submit that a main problem with the respondents' construction of Section 9 of the Act is that on their approach, the Act does not allow for scrutiny of what we say, and I referred to earlier, defined earlier, as the original judgment, in this case, the Singapore judgment, or the application of the various conditions that are laid down both in the 1920 Act and also laid down in the 1933 Act, does not allow for, on his construction, scrutiny of those provisions, or the applicability of those provisions to the original source judgment, that is, in this case, the Singapore judgment. And in fact, it may be said, and we'll need to consider this, it may be said to be, in fact, an even worse situation than that, because it may be said that the ban on considering the merits of the judgment which the English court is being asked to register or give effect to by way of a common law judgment would positively preclude consideration of the underlying qualifications, the underlying conditions insofar as they applied to the Singapore judgment. Whereas it is fundamental to the English court's approach that it must, and this is what both acts provide, it must consider whether such conditions as whether the original court had jurisdiction, whether there was a submission to the jurisdiction, whether the foreign court judgment is contrary to public policy, and so on. It is fundamental to the English system under both the 1920 and the 1933 Act that the court has to consider those matters. A related problem we submit with my friend's construction of an approach to the Act is that the Act plainly only provides for two judgments. It's all about the judgment of an original court and a judgment of the registering, and what happens to that in the English registering court. And likewise, it only seems to contemplate two stages. And I'll be developing that point, but it reflects what I said at the outset, that here, what we are being asked to consider is a three-stage or a three-court problem. Finally, before I turn to facts and looking at some of the law, I don't know whether your lordships, your ladyship, has seen an email from myself to Mr. Reza sent this morning, in which I make two concessions about errors that we made in our skeleton and in our note.
Yes, well, I have it, I think. My lord and my lady do as well.
Well, the first point is quite simply that I was wrong to say it was not legitimate to look at a later act when you're construing or working out the meaning of an earlier one. And I've brought the relevant passage from Benyon. I'll tell your lordship a bit more about that in due course. And the second point was we developed a case on merger in our most recent note, and it's only in part applicable. The fact is that at common law, the position is the cause of action on which a foreign judgment was based was not held or thought to merge in the foreign judgment, and that was corrected by the 1982 Act. But my most recent note, and we may need to look at the point in a little bit more detail in due course, but my most recent note treated the effect of, at common law, treated the effect of the Cayman Islands judgment as extinguishing, if you like, the Cayman Islands cause of action. That is not the case as a matter of common law. The 1982 Act, by section 34, imposes what might be called some form of technical statutory merger. So that was an error, and we don't pursue that point. Now, from there, and I can do this quite briefly, to remind your lordship and ladyship of the course of events, it's best seen from the chronology behind divider 5 in the core bundle. And essentially we have a set of facts here which could as well do as an exam question. They're very simple and the basic facts can't be in dispute. And we don't need to look at all these events.
I think you can take it we're reasonably familiar.
Right. Well, what I'm going to do, you've got the chronology there.
Yes.
I'll just run through them very quickly. 1998, issue of proceedings. In fact, the chronology doesn't record that the proceedings themselves in Singapore were issued on the 8th of May 1998. You see that from paragraph 10 of the judgment. And an unqualified appearance was entered. Again, this doesn't record it. An unqualified appearance was entered by my clients on the 8th of July of 1998. And then in 1999 and 2002 were the Singapore default judgments. That's at the top of page 48 of the bundle. Curious event in December 2004. Well, not curious in itself, but the aftermath is. In December 2004, the respondent was in fact given permission to register the Singapore judgment in England, but they didn't pursue that. And no explanation for that was given. The judge comments on that in her judgment. But then getting on for, well, over 4 years later, in December 2008, the Cayman Islands writ is issued. 2009, 25th of June, there's the Cayman Islands default judgment. 2014, there's the important, this is over the page, there's the important consent order in the Cayman Islands, and that's at tab 36, page 172 of the bundle, of the supplementary bundle. That's important because that was key to the judge's findings that my clients had submitted to the jurisdiction of the Cayman Islands Court. We sought to challenge that, but were refused permission both by her and by this court. In 2016, we see the permission being granted to register the Cayman Islands default judgment in this jurisdiction. January 2019 is our application to set aside the registration, raising all the plethora of issues that the judge eventually had to deal with. And then in 2020, 21st of February, the judgment and the order appealed against. And again, I'm sure the court is aware of this, but the only parts of the judgment which really matter for the purposes of the appeal are the statement of the question at paragraph 45 paragraph 45 on page 93 of the core bundle, and the question is at 45.3b, does the AJA apply at all? That's the question. And then that is answered relatively simply at paragraph 83 on page 102 to paragraph 87 on page 104 of the bundle. And I'm going to assume that the court has read those passages. But as far as I know, and Mr. Razor may differ from me on this, but as far as I'm concerned, there are really no other parts of the judgment that the court needs to be concerned with for the purposes of this appeal. Now, moving there to our main argument, can I just tell the court what the order in which I'm proposing to deal with things?
Yeah.
What I want to do first, subject to the court thinking it's sensible, is to have a broad, relatively brief overview of the regimes current now in England and Wales for the enforcement of foreign judgments. And one of the reasons I do that is that at any rate in our submission and on the respondent's case, the Section 9 of the AJA 1920 is a complete outlier. It is the only provision, if we're right about the common law and we're right about the statutory regimes, including European regimes, it is the only enforcement of foreign judgment system which allows for the enforcement of judgments on judgments in this jurisdiction. And I'll obviously need to make that good. Secondly, I want to say a bit about the principles of statutory construction. They'll be very well known to the court, but there are really three principles I want to bring out. That in general, where there is a common law background to a statute, in general, obviously subject to exceptions and subject to departures, but in general, no departure from the common law is intended, or Parliament cannot be regarded as having intended a departure from the common law, in general. Secondly, and I've mentioned this point already, is the matter of a purposive construction. That's the standard way of approaching an act, assuming that you can determine what the purpose is. And having ascertained the purpose, you may, we submit you don't have to in this case, but we would say the court could do so if the court thought it was necessary. You may have to resort to a strained construction of the language. And the third point is the one I mentioned earlier, that it is permissible to use later legislation to construe the earlier. And then what I want to do is to review some of the commentaries and authorities that are in the authorities bundle. Fourthly, then look at, but it will be largely by way of drawing from what I've already taken your lordships to certain conclusions, the common law position, and whether, as a matter of common law, a judgment on a judgment is enforceable. As far as we can see, that has never been...
rather sort of duplicates, doesn't it, your brief overview of the regimes?
It won't.
It won't. Because the point of that is to show that Section 9 is an outlier.
Well, it is, but take it from me.
It won't. All right.
I should be able to deal with that point
right.
very, very briefly.
Okay.
I'm not going to duplicate submissions.
I'm sure you're not. No.
But there is a curiosity here, which, as far as we can see, that specific point, a decision that, a conclusion that, as a matter of English common law, a judgment on a judgment is not enforceable, has never itself been explicitly decided. At least we can't find a decision. It is the direction we submit that the authorities and the textbooks take the decision to be made by the court, but as far as we can see, it hasn't been definitively decided. And then again, without any attempt at duplication, I should say my review of the overall situation is going to be pretty bird's eye. It's going to be somewhat broad. So there will be matters which we'll need to come to when we look at the detail of the acts that require more specific submissions. But I'm from there going to look a bit more closely at the legislation. And then I'm going to summarise our main submissions as to why a judgment on a judgment is not within the 1920 Act. And those will largely be drawn from the written submission and certain other points that inevitably arise when one looks more closely at the statute in the lead up, statutes and other material in the lead up to an appeal. And finally, to the extent that the court would like to hear from me on this, I have some responses to make to Mr. Reza's points, but those have largely been covered already in my quite long supplementary skeleton, which was a point-by-point response.
Well, you may have got the message that the court likes well-focused oral submissions.
I know. I've got that. I've got that message. Overview. We haven't included in the bundle, but for the court's note, there is quite a useful summary, introductory summary of the whole regime in Rule 41 of Dicey. But what I'm going to give you now is a précis, essentially, of what you find there and in certain other places. But it's as far as we can see, not in any sense controversial. That introduction itself does not deal with the point that is an issue on this appeal, which obviously is controversial. But starting with the common law approach, that remains as a method of enforcing foreign judgments. That remains essentially, except where it's been excluded by the 1933 Act, by the Brussels Convention, then regulation, now the recast regulation, and the same applies to the Lugano Convention. And the common enforcement of a judgment at common law remains a very, very significant part of the English court's armoury because, for example, as I understand it, there are no relevant conventions with the United States and quite a number of other jurisdictions around the world which can only, outside the European Union, outside the terms of the 1933 and 1920 Act, which can only enforce their judgments here by way of action on common law action on the judgment. And so far as the common law position is concerned, the consensus we submit of the commentary, which I'll take the court to, is that a judgment creditor cannot bring a common law action on a judgment on a judgment. And it doesn't seem, we'll hear from Mr. Reza in due course, that doesn't seem to be disputed by Mr. Reza's side. I made that point twice in our supplementary skeleton for the court's note, paragraph 9, little 1 and 20, little 2, to which my friend then responded without any sense of disagreement. So that's the common law position. Secondly, English statute, and we've got two in play. We know what they are. They're the 1920 Act and the 1933 Act. And again, by way of broad overview, I'm not going to invite you at this stage to turn up the provisions of the Act. They both provide, let's consider the 1920 Act first. It provides for a registration process. It provides for a number of situations in which there cannot be registration, all drawn from the common law, no jurisdiction in the original court, if the defendant was not within the territorial jurisdiction of the original court, the fact that he did not submit to the jurisdiction, where there has been no due service and appearance, where there's been fraud, where there's an appeal pending. That was a special addition but then going back to the incorporation of general English common law principles where the enforcement of the judgment would be contrary to public policy or, as the Act says, some other similar reason. Two further points just in broad overview about the 1920 Act. It provides for a discretion, which the 1933 Act doesn't. There is an ultimate backstop, and we'll look at this a bit later, that Section 9 of the 1920 Act provides, which is essentially that even if the judgment does not offend against any of the common law categories of non-enforceable judgment, of a non-enforceable judgment in England, there's nonetheless a discretion in the court as to whether or not to allow, whether or not to set aside the registration. And the second point, which again I'll come back to, is this. In terms of its coverage of the common law scene, if you like, it's not comprehensive. For example, and this is important because we say it's not comprehensive in the respect that we are talking about today, but a clearer example of that is it doesn't, for example, provide that the foreign judgment has to be final and conclusive. And when we look at the 1933 Act, we'll see that it does provide that. But no one has ever suggested, and it's confirmed in Professor Patchett's book, which again we'll look at later, no one has ever suggested that it's not essential to the 1920 Act that the foreign judgment, which it is sought to register, should not be final and conclusive. So that's a very broad overview. Obviously, we'll look at the Act itself in due course. Then there's the 1933 Act. Again, a registration process, and as we'll see, particularly when we look at the Greer Committee report, as we'll see, it's built on and indeed anticipated in some respects by what went on in 1920, but it's all based on a registration process as well. But there is no discretion. There's a series of set rules, and we'll see why that was when we look at the Greer Committee report. It was to make sure that the foreign courts understood that the English provisions for enforcement of their own judgments were as tight, if you like, as their own, and there was no room for discretion. We'll see how that was dealt with and discussed in the Greer Committee report. Of course, the other significant difference now between the 1933 Act and the 1920 Act is that since 1982, there's been a new section 1(2)(a), which does ban or exclude judgments on judgments. And there are various other provisions which we'll look at in due course, which we say, when we're looking at the 1933 Act, do point almost conclusively to the fact that when the 1933 Act talks about the original court, talks about the judgment of the original court, it is talking about the true original court, not some form of intermediate court. And we say there are a number of provisions which point strongly in that direction. And that, the reason that's important is we submit that the common law, the 1920 Act, and the 1933 Act all have to be seen as part and parcel of the same exercise, if you like. And the fact that you find indications in the 1933 Act, which I will submit you also find in the 1920 Act, that it can only be referring to the judgment of the true original court, are, if not equally significant, because one's naturally focusing on the 1920 Act, but if you find the same things in the 1933 Act, especially given its background, then that is highly significant so far as the construction of the 1920 Act is concerned.
So the amendment that was made to the 1933 Act, you submit, was for the avoidance of doubt.
It's not entirely clear. Mr. Reza will have some things to say about this. It's not entirely clear
But
why.
I mean, for the purposes of your submission, it's got to be, hasn't it?
Yes. Yes.
All right. So your submission will be that it's designed to
confirmatory.
avoid doubt. It's confirmatory.
It's confirmatory. It
Yes.
does not change the law and cannot have changed the law.
No. Right, thank you.
So that's the English statutory position. Then looking at the European position under the Brussels Convention, then the Brussels I regulation, and now the Brussels I regulation recast, and for that matter, the Lugano Convention. The position is this, that it has been definitively decided by the European Court of Justice in a case that derived from this jurisdiction, Owens Bank and Bracco, the ECJ, not the House of Lords decision, that the Brussels Convention and European law generally, and the judgment of, and the law of the various constituent states in the European Union do not allow for the enforcement of judgments on judgments. This is important background, and it's probably the right moment just to take the court briefly to that decision. It's in Authorities Bundle 1, and there are two Owens Bank and Bracco decisions, one in the House of Lords, but what the House of Lords did was refer a key question to the ECJ, and you'll find that behind divider 7 in the first Authorities Bundle. And this best explains how how judgments on judgments fit or don't fit within the Brussels and Lugano regimes. In brief, what we had here was an original judgment on a debt in the High Court of St Vincent's and the Grenadines. In 1989, the bank began proceedings in Italy, and in 1990, the bank applied for registration in England of their St Vincent judgment under Section 9 of the 1920 Act. And the question that the House of Lords referred to the ECJ was whether the Brussels Convention applied to judgments of non-contracting states. And the ECJ decided that it did not, and they reasoned that from the ban on double execution, both under the Brussels Convention regime and by reference to the to a principle of a number of civil law systems. And we conceal that in the opinion of the Advocate General at paragraphs 20 to 23. And this whole passage will probably reward a closer examination, but can I just take you to a few aspects of it, just to show you the court what how the Advocate General is analysing matters. It's introduced as follows in paragraph 20. The parties which have taken part in the proceedings before this court are agreed that a decision by which a court in a contracting state recognises and declares enforceable a decision given in another state cannot itself be recognised and declared enforceable pursuant to Title 3 of the Brussels Convention in another contracting state. And then the reasons for that are analysed by reference to commentary and by reference to the words of Article 31 of the Brussels Convention, when the order for its enforcement has been issued there, and then at the top of page 523, the Advocate General said the effects of that declaration of enforceability are restricted to the state in whose courts that declaration has been made. Where the judgment is also to be enforced in Spain, it must first also be declared enforceable by the Spanish courts. And then the argument is expanded, apparent both from the wording of Article 31 and from the nature of such proceedings. And then in 22, they're now moving into the question before, the Advocate General is now moving into the question before the court, which is the applicability of the Brussels Convention to judgments of non-contracting states. And 22, a decision by a contracting state whereby a judgment of a non-contracting state is declared enforceable takes effect only in that contracting state. Where the judgment of the non-contracting state is also to be enforced in another contracting state, the judgment creditor must apply to the courts of that contracting state for a declaration that the judgment of the non-contracting state is enforceable in that contracting state. Both cases concern proceedings governed solely by the law of the contracting state in question, including any conventions existing between that contracting state and the non-contracting state. On the other hand, Title III of the Brussels Convention does not apply to those proceedings. This means in particular that the decision of contracting state A, by which the judgment of the non-contracting state is declared enforceable in that contracting state, cannot be enforced in contracting state B, pursuant to Article 31 et sec of the Convention. And then there's an important passage about the principle of double execution and comments to the effect that it's dangerous and, paraphrasing, undesirable. And it's a position that was taken up by the United Kingdom itself. To permit such double execution would, as the United Kingdom right, the danger that a judgment creditor could circumvent the conditions laid down by a contracting state for the recognition of judgments of the courts of the non-contracting state in question. If, for example, contracting state A makes the recognition and enforcement of a judgment of the courts of the non-contracting state conditional on certain criteria, whereas judgments from that non-contracting state are declared enforceable unconditionally in contracting state B, the judgment creditor could first obtain a declaration of enforceability in contracting state B and then, pursuant to Article 31, enforce the judgment without difficulty in contracting state B by virtue of the decision obtained in contracting state B. Share the United Kingdom's view that it is not the aim of the Brussels Convention to enable judgment creditors to engage in such forum shopping. We've called it judgment trafficking. They call it forum shopping. And then there's reference to a very large number of authorities which support the non-inclusion of judgments on judgments. That's all in the second half of paragraph 22. And of course, as the court will appreciate, the problem or the danger or the undesirable feature that is identified in that passage that I read out from to permit such double execution is precisely the situation we're facing here in our appeal. And then, beginning of 23, this at any rate is the view of the Advocate General. In my view, this view also applies where the judgment of the non-contracting state is not declared as enforceable as such in the contracting state, but is made the basis of civil proceedings. So that appears to be saying, if one translates that into an English context, it's not simply applying to a situation where you've registered the foreign judgment, it would also apply to a common law action on the judgment. And then lower down in that paragraph, similar sentiments are expressed at about 6 lines from the bottom. The decision regarding such an actio judicatae is also apt to facilitate the enforcement of the judgment of the non-contracting state in the contracting state in question. If it were permissible for such a decision to be declared enforceable in another contracting state on the basis of the provisions of Title III of the Brussels Convention, this would not only provide the judgment creditor with the opportunities described above of circumventing the rules applying to recognition, but would also, as will be shown hereafter, throw into disarray the jurisdictional system laid down in the Convention. And as far as we're aware, and there's no reason why it shouldn't still be the same, exactly the same principles, provisions, thinking would apply to both the Brussels I regulation from 2001 and then the recast Brussels regulation from 2015. So that's a very clear expression of the situation under the Brussels Convention. And
you've shown us the Advocate General. Does the court endorse that reasoning?
The court does not. The court deals with all these matters relatively summarily. And if one turns, please, to page 543 of the judgment, dealing with the first and second questions. The questions themselves are set out in paragraph 8. And essentially, we're concerned here with questions 1 and 2. And then the court goes on, since the first and second questions are closely linked, they'll be examined together. And then there's reference to what the Advocate General has explained in paragraphs 7 and 8 of his judgment. And there's a description of a summary of the 1920 Act. And then the court's reasoning is really quite simple. Paragraph 15, the defendants maintain that such proceedings involve civil and commercial matters as defined in Article 1 of the Convention and consequently fall within the scope of the Convention. That view cannot be accepted. And then they simply refer there to the fact that Title 3 can only apply in the case of decisions given by the courts of a contracting state. Then there is, I couldn't see anything in this judgment that focuses specifically on the judgment on a judgment point. I don't think there is anything there. But the reason I took the court primarily to the Attorney General's opinion is that it is for the clarity of its summary of the position both under the Brussels Convention and, as it appears, under civil law systems generally. I can't say that what the Attorney General said there is specifically, as far as I can see, is specifically endorsed by the judgment itself.
No, it looks as if they reached the same conclusion, but as is not uncommon, the reasoning is somewhat sparser than the Advocate General's.
Exactly. Since we're in the statutory context and the European context, it's worth mentioning just this. Within the United Kingdom, within the component parts of the United Kingdom, and it's not in the bundle, but I'll give your lordships the reference, and I can provide a copy over the short adjournment if necessary. Section 18.7 of the 1982 Act precludes enforcement of a judgment on a judgment as between England and Scotland, or England and Northern Ireland, etc. That's section 18, subsection 7 of the 1982 Act.
Is that because there's an alternative enforcement mechanism? I mean, if you obtain a judgment in Scotland and seek to enforce it in England, how do you go about doing it?
That's under the 1868 Act.
Oh, yes, I haven't.
I mean,
there
why
was.
would you want
there
to
was
get
go
a
back to
judgment?
1868.
Yeah, but why would you want to get a judgment on it? Why would you want to get an English judgment on a Scottish judgment?
Quite. I mean, yes, but the fact is that section 18.7 explicitly excludes.
Well, that may be because they don't want. Anyway.
Well, it may or may not be. The only purpose of this overall review is to seek to demonstrate that on the Friends case, section 9 of the AJA, which he says permits enforcement of a judgment on a judgment, is an outlier.
I follow.
We can look. I can no doubt find the answer to your lordship.
No, I mean, don't worry, but it didn't seem to me that it was possibly pertinent, really, in this context.
Well, I'm mentioning it for completion only. Then I wanted to say one or two things about statutory construction. You will have in the bundle at tab 23, that's in the second authorities bundle. An extract from Benyon, reasonably well-known stuff, dealing with the question of the purposive approach, and I'm just going to refer the court, in the interest of time, to certain passages and draw particular attention to some.
So this is tab 23.
Tab 23.
23, thank you.
And the first passage is one from Chapter 11 of Benyon, section 11.1, presumption that enactment to be given a purposive construction. And it reads, 1. In construing an enactment, the court should aim to give effect to the legislative purpose. A purposive construction of an enactment is a construction that interprets the enactment's language so far as possible in a way which best gives effect to the enactment's purpose. Purposive construction may accord with a grammatical instruction or may require a strained construction. And then
the index tells us that this is the 6th and presumably current edition. Can you tell us what the date of that edition is?
this was Mr. Reza's contribution. Was it? Right. I'm told it's my contribution. I'll find out.
Right, if you would.
I
thank you.
will find out. That is the 7th edition.
It looks like it's from Lexis.
Well, I'm told by Miss Jones that it comes from Lexis and it will be the 7th edition.
So
But we'll check that.
All right.
It's obviously important, but the
If you,
principle.
it may not have changed, but if you could just check
No, no,
what
absolutely,
the current
of course,
version
yeah,
is,
of
what
course.
the date of that is, and make sure we've got the right one.
No, of course. Then, again, many of these examples say much the same thing, but for example, moving on to, there's no internal page numbers, but moving on to the 3rd page, there's an example given from Pollen Estate Trustee Company, and it's pointed out that Lord Justice Lewison said the modern approach to statutory construction is to have regard to the purpose of a particular provision and interpret its language so far as possible in a way which best gives effect to that purpose.
I think this is quite familiar territory.
Right. Well, let me just draw attention to the passages without reading them or anything of that sort. There's a useful extract from Stock and Frank Jones on the bottom half of that page. There's a useful example from the Camins ballroom case on strained construction at the bottom of what would be page 5, over the page. And there's a useful, and then goes on to section 11.2. Benyon summarises, if you like, the tools and aids to establishing the legislative purpose, and again and then moving on, not from chapter 11, but from chapter 24, which for some reason does have, as soon as you get into pages with numbers 1 to 5, Benyon points out the legitimacy of using government reports and reports by parliamentary committees.
So where are we? I'm
I'm so sorry. If one turns on in that
Are we at parliamentary history and later?
parliamentary history and later material.
Yes. Okay.
Again, this is completely uncontroversial, but it is
Yes.
important background because the court's being asked to look at both the Sumner and Greer reports. That's all entirely legitimate. And then in the supplementary bundle of authorities, at tab 4, there's some extracts from Benyon on the use of the common law, or the significance of the common law in interpreting statutes. And really, again, because this is pretty well-known territory,
Well, where is, what do you want to see?
it's tab 4 in the supplemental
Yes.
bundle. And it's all from chapter 25 of Benyon. And if you turn, this is numbered at the top of the page.
Yes.
The key parts, page 4, they're all sidelined.
Yes.
Incorporating or attracting the common law. For example, where an act uses a similar but not identical legal concept, question as to whether or not Parliament intended to attract the existing legal rules or principles, wholly or in part. But the more useful provisions, most useful principles are stated at page 8 in 25.3. Interpretation and effect of act informed by relevant law. And the obvious comment, an act is rarely self-sufficient in almost all cases. An understanding of its application, meaning or effect will depend on an understanding of general principles in existing law in the area with which the act is concerned. And then page 10, again sidelined. Interpretation most consistent with relevant common law. Second sentence, the courts will usually adopt a construction which is most consistent with the area of law to which the act relates. And then if one then again goes on to 25.6, point I mentioned earlier, page 20, there's a presumption against changes to the common law, and presumption against changes to the common law in accordance with the doctrine of parliamentary sovereignty. Parliament may abolish, modify or displace any existing common law rule, but there remains a general presumption that Parliament does not intend to make changes to the common law. And then, again, a passage is sidelined on the next page, and at 25.9, and then over the page 29, under implied displacement of common law, general principle, an act of Parliament may impliedly displace the common law. And considering whether an act has this effect, the courts will consider the extent to which the legislative purpose will be undermined.
Very sorry, I'm lost again. Where
I'm so sorry, page 27.
27. Yep.
May impliedly displace, Act of Parliament may impliedly displace the common law, and considering whether an act has this effect, the courts will consider the extent to which the legislative purpose will be undermined by the common law continuing to operate alongside it. And then we've drawn attention to and sidelined various passages, both on that page, page 29 and page 30.
It looks as if the case which is sidelined at page 21 may be relevant, because that's specifically on the issue of enforcement of judgments.
Indeed.
Have we got that one?
We haven't got that in the bundle. We can get it.
Right, well,
What I was going to show you, Lordship, though...
leave you to tell us whether it's relevant or not, but it looks as if it might be.
Well, it may be, but more relevant, in fact, and I shouldn't have passed over it, is on page 11, which itself talks about Owens, Bank and Bracco. This is the House of Lords decision in Owens, Bank and Bracco, which we can have a look at. And it's a slightly different point. That was the case in which it was being argued. That was the aspect of the case in which it was being argued that the way in which you established that the original judgment was obtained by fraud was limited by the English common law rules that you would have to prove the fraud by new evidence and so on and so forth. And the House of Lords says, no, that's not right. we can look at that as and when. But the point about Owens Bank and Bracco in the House of Lords is that it construed, one sees the conclusion the House of Lords rejected that argument on the basis that the common law rule did not apply to foreign judgments, and section 9.2d followed the same approach. And we do have the House of Lords judgment in the bundle. And the final point on statutory construction, we haven't got the text, but we've provided it to my friend, and we can make it available over the short adjournment if necessary. It's in Benyon 24, chapter 24, paragraph 19, and it's the simple point that you can rely on later legislation.
Well, you say it's a simple point, but for my part, I would like to understand the circumstances in which you can do.
Well, let me provide those extracts. The three there. Three copies there. Thanks. And the general principle is stated at 2419. Where the legal meaning of an enactment is doubtful, subsequent legislation on the same subject may be relied on as persuasive authority as to its meaning. And that principle is then expanded about 2/3 of the way down the page. Where, however, the legal meaning of an enactment is doubtful, a later act may be treated as a persuasive authority if it indicates that Parliament took a particular view of the existing law. Similarly, where Parliament passes an act which on one but not the other of two disputed views of the existing law is unnecessary, this may be taken to suggest that the other view is correct. And then there's another number of examples given. Perhaps the most helpful of which is the first, the Cape Brandy case.
Is this applying in cases where you're seeking to construe the first act in time and subsequent legislation has amended that act?
I don't think it's not. We wouldn't regard it as confined to that. No. Because
but that seems to be what Cape Brandy is directed at.
It's always going to be a question of fact and degree, to the extent to which you can, if you like, ascertain some relationship between the statutes. For example, you may have a term defined in a later statute, which is not going to help at all with its definition in an earlier statute, which is completely outside the area with which the second statute deals, for example. This principle, we would submit, is particularly helpful in this case, and we'll come to this in a few minutes, when one looks at the relationship between the 1920 Act and the 1933 Act, and what in the interim the Greer Committee said about it.
Right. Okay, thank you.
But I mean, the basic point is made in the citation from IRC and Dowdall O'Mahony, which is that the beliefs or assumptions of those who frame acts of Parliament cannot make the law.
Yes, but it can be of persuasive authority, the way in which they've approached matters in a later statute.
I mean, just to illustrate the point, I mean, if we were concerned with the application of the 1933 Act, as it were, as at a time before the amendment had taken effect, then the amendment would be highly in point. But we're here concerned with the 1920 Act.
Yes.
So the question is, why do you construe the 1920 Act by reference to the 1933 Act?
Well, all I'm submitting is that the way in which it's examined both by the Greer Committee and then put into effect in the 1933 Act is of some
all right. I mean, they
persuasive
could be said to be
significance.
Yes. All right. Thank you.
For example, it's not just Parliament, if you like. We do have Lord Justice Greer analysing, in the same way, I suppose, in a way, as we're now looking at the way in which Lord Collins deals with things in Dicey or something of that sort.
Yes.
Just analysing what the effect of the 1920 Act is.
What he has to say is important, I agree.
And from there, I did want to turn, if I may, to the authorities and commentators, and starting with Dicey, which is behind divider 20 in the Second Authorities Bible. And in general, there are 3 points I wish to draw from the review that I'm now going to invite you to undertake, and at some pace, because I'm conscious of the time. And the first is that to be enforceable, a foreign judgment must be final and conclusive on the merits. The second is, at any rate, a general consensus, when we look at what the commentators and so on have to say, that a judgment on a judgment is not permitted at common law. And the third is the consensus that the 1920 and the 1933 Acts follow the common law, and that's reinforced by both the Sumner and Greer reports. And in the way of things, the leading commentators, Dicey then Briggs, but there's useful contributions from Professor Patchett and then an article from a Professor Smart. In the way of things, they deal with the points we're concerned with in various places, and I'm just going to move as quickly as I can through the extracts that we rely on. And we start behind divider 20 with Dicey, with the common law rule, Rule 42, subject to the exceptions hereinafter mentioned, and to Rule 62, a foreign judgment in personam given by the court of a foreign country with jurisdiction to give that judgment in accordance with the principle set out in Rules 43 to 46, which is not impeachable under any of Rules 49 to 54, may be enforced by a claim or counterclaim for the amount due under it, if the judgment is, first, for a debt or definite sum of money, not being a sum payable in respect of taxes or other charges of a like nature, or in respect of a fine or other penalty, and B, final and conclusive. And then there's some proviso, there's a proviso over the page that a foreign judgment may be final and conclusive though it is subject to an appeal, and though an appeal against it is actually pending in the foreign country where it was given. And then there's an equivalent provision in relation to recognition, and under 2, and then there's a recognition, reproduction, if you like, of the provision that I referred to earlier, Section 34 of the Civil Jurisdiction Judgments Act, that essentially imposes a technical, if you like, merger principle on the foreign judgment, preventing relitigation in this jurisdiction. Then we can turn right on in the passages we wish to draw your Lordship's attention to Rule. Well, it is worth just noting on the way, page 692 under Rule 43, we'll come to something more specific on this in due course, but 1459, this is dealing with the 1933 Act, deliberately framed so as to reproduce the rules of the common law as closely as possible. Though as the Foreign Judgments Reciprocal Enforcement Committee, that's the Greer Committee, conceded, it was found desirable to make one or two departures from the common law rules in order to secure international agreements which would be likely to operate satisfactorily in practice. And then Rule 48, a foreign judgment which is final and conclusive on the merits and not impeachable under any of Rules 49 to 52, is conclusive as to any matter thereby adjudicated upon and cannot be impeached for any error either of fact or of law. And then there's commentary at 119 and 120, and then there's this very important passage dealing with the common law position. It is unlikely, at 121, it is unlikely, however, that judgment in this sense extends to a decision of a foreign court, that the judgment of a court of a third country is entitled to be enforced under the law of the foreign country, even where the proceedings in the foreign court were contested by parties who submitted to its jurisdiction in relation to this issue. The civil law principle, and we've seen this referred to in the Owens and Bracco case, the civil law principle that exequatur sur exequatur ne vaut is sometimes used to explain why a judgment from the third state is not converted into an enforceable foreign judgment by virtue of its recognition or enforcement or endorsement by another court. Though no English case expressly so holds, the principle is sound for at least three reasons. The effect of the foreign proceedings will often only be to declare the third country judgment to be enforceable, executable within the territory of the foreign court, an order which by its very terms can have no effect in England. The foreign judgment will not usually be on the merits of the claim, and because of the confusion liable to result if both the judgment of the third country and the foreign enforcement judgment were to be separately enforceable in England. And then it goes on to point out that there's no reason why issue estoppel may not apply. Care needs to be taken with the Yukos capital decision because, as the Dicey supplement shows, that was in fact reversed on appeal, and we don't need to be, and so I'm not going to take your lordship to anything of that. And then there's 122, which I simply note, reading that was what caused me to withdraw what I had said about the common law effect of, for our purposes, the Cayman Islands judgment, and my assertion that at common law, the cause of action in Cayman had merged in that judgment. And then that's really all I wish to show you in Dicey. There will be further passages in Briggs. We have included, behind Divider 21, some extracts from Dicey as it stood in 1922, from the third edition. And it doesn't take matters a great deal further, save to show that key principles, key rules, as Dicey regarded them, were then in place. As you will recognise, it comes immediately after, very shortly after the passing of the 1920 Act. But for example, at page 444, Rule 112, a valid foreign judgment is conclusive as to any matter thereby adjudicated upon and cannot be impeached for any other error either of fact or of law. And then there is a relatively long comment on that, which is there for your lordships to look at should you feel inclined to do so. In the interest of time, I'm not going to linger on that. And then Rule 114, page 448. Subject to the possible exception hereinafter mentioned, a valid foreign judgment in persona may be enforced by an action for the amount due under it if the judgment is 1, for a debt or definite sum of money, and 2, final and conclusive, but not otherwise. and that is, there is then, yes, there is then over the page, but we'll be looking at this at any rate at the House of Lords judgment in a moment, what's primarily relied on for that principle is the case of Nuvian and Freeman, and there's a long there's an extract from that at pages 449 to 450. And then there is, he deals at page 462 under Rule 117 with the 1920 Act. And it's worth simply noting this at the top of page 464. The cases in which registration is forbidden agree in general with those in which recognition would be refused to judgments of foreign courts. In other words, the common law position, but it is expressly provided that the pendency of an appeal or the intention of the judgment debtor to exercise a right of appeal appertaining to him will bar registration. Now, from there,
the third edition didn't, by the look of it, include the passage about judgment on a judgment, which you've shown us in the latest edition. Do you know when that came in?
Miss Jones was the one who had a trawl through previous editions of Dicey. We can find out.
It may not matter, but just
no. It is of some interest. We'll find out. From there, perhaps it would be good to turn back to the first authorities bundle, tab 4, and look at the Nuvion case. Now, the facts of this case do not have any direct relevance to ours. This was a case in which something called a remate judgment had been obtained by the claimant, by the plaintiff, in Spain. That was essentially a form of provisional judgment, which could be confirmed or reversed by way of a plenary judgment in the Spanish courts. And really the simple point on which the House of Lords ultimately dealt with this was that the remate judgment, which was liable to be overturned, and for that matter confirmed, could not be sufficiently regarded as final and conclusive for the purpose of the common law approach to enforcement of foreign judgments. And we see that, we see the description in the head note, and the head note simply says that the result affirming the decision of the Court of Appeal, since a remate judgment does not finally and conclusively establish the existence of a debt, no action can be brought upon it in this country. And then the key passages, and in the interest of time, I really will refer you generally, please, to pages 8 to 12 in Lord Herschel's judgment.
Beginning with "Now, my lords, there can be no."
Beginning with "Now, my lords," yes. I mean, the previous paragraph sets out the point in question. And towards the bottom of the page, Lord Herschel says, but it was conceded, and necessarily conceded by the learned counsel for the appellant, that a judgment, to come within the terms of the law properly laid down, must be a judgment which results from an adjudication of a court of competent jurisdiction, such judgment being final and conclusive. Shall, of course, have something to say upon the meaning which was given to those words. And then there's this, again, focusing on the way in which I suppose it might be put in this case. The appellant contends that that the judgment is final and conclusive.
So
And I'm reading from the fifth line of page 9.
Okay.
And no doubt, in a certain sense, that must be conceded. It puts an end to and absolutely concludes that particular action. About that, there can be no manner of doubt. In that sense, it is final and conclusive. But the same may be said of some interlocutory judgments upon which there can be no question that action could not be maintained. They do settle and conclude the particular proceeding, the interlocutory proceeding, which the judgment is pronounced. It's obvious, therefore, that the mere fact that the judgment puts an end to and finally settles the controversy which arose in the particular proceeding is not of itself sufficient to make it a final and conclusive judgment on which an action may be maintained in the courts of this country. And then he says, "My lords, I think that in order to establish that such a judgment has been pronounced, it must be shown that in the court by which it was pronounced, it conclusively, finally, and forever established the existence of the debt of which it is sought to be made conclusive evidence in this country, so as to make it res judicata between the parties." And then he deals more with the facts that faced the court in that case, and says that he doesn't believe that judgment of that character can be regarded as finally and conclusively evidencing the debt. And then this, the principle on which I think our enforcement of foreign judgments must proceed is this, that in a court of competent jurisdiction, which according to its established procedure, the whole merits of the case were open, at all events, to the parties, however much they may have failed to take advantage of them or may have waived any of their rights, a final adjudication has been given that a debt or obligation exists, which cannot thereafter in that court be disputed and can only be questioned in an appeal to a higher tribunal. In such a case, it may well be said that giving credit to the courts of another country prepared to take the fact that such adjudication has been made as establishing the existence of the debt or obligation, and then, whereas in this present case, adjudication is consistent with the non-existence of the debt or obligation which is sought to enforce, dealing there with the particular peculiar facts of that case. And then lower down, no, I don't think we need to refer to that. The other passages that I would draw your lordship's attention to, all their lordships agree with and adopt what Lord Herschel says. There are one or two other points that emerge from the judgments of Lord Bramwell and Lord Ashbourne, in particular in that of Lord Bramwell at page 16. And Lordship, give me a moment. Yes, at the top of page 16, Lord Bramwell says, "There was a matter brought forward prominently by my noble and learned friend on my left, Lord Ashbourne, which I think is entitled to consideration. And that was that if we should give judgment for this plaintiff here, he'd be better off than he would be if there were mere affirmance of the judgment, which with all its consequences in Spain, because in Spain the judgment that he has got is liable to be defeated. But if judgment were given from him here, there would not be that liability to be defeated by proceedings being taken here analogous to the plenary proceedings in Spain." And we do say that's not of direct application to what we're dealing with here, because he's dealing with the particular situation. But the truth of the matter is that in this case, the claimant would potentially be better off in this jurisdiction than if he had sued on or sought to register the Singapore judgment here, because that would, if he sought to do that, it would have to involve and would have involved consideration of the circumstances which existed in Singapore when the Singapore judgment was given, and would have allowed, at any rate, we're dealing here with the question of principle, it doesn't need to be related to the particular facts of this case, and would have allowed an examination of whether the Singapore court had jurisdiction, as to whether or not it was contrary to public policy. I'm not suggesting that any of those things reflect the real position, but this reinforces the principle of it, that under the English regime, as this claimant has sought to apply it, those matters, what happened in the Singapore court, are simply not open to question other than under the discretionary provisions provided for in the 1920 Act.
Well, public policy, I suppose, is... I'm sorry.
No, you can.
Public policy, I suppose, is quite an interesting example because
Yes.
one can conceive of circumstances where something might be contrary to English public policy to do with the original cause of
Yes.
action or whatever, but not contrary to Cayman Islands
Exactly.
or whatever the intermediate court is.
Or
And that would be a way, therefore, I suppose, of getting your judgment enforceable in England, which you couldn't have done directly.
And also, my lord, if the Cayman court simply, bear in mind what happened in this case, was that the Cayman court was was entering a default judgment on the Singapore judgment. If the Cayman court gets it completely, if the Cayman court, for example, is asked to consider whether the Singapore court had jurisdiction, but gets that completely wrong in a way in which, in England, looking at it from a distance back via Cayman into Singapore, an English court would also say it got it wrong, except by resort to the discretion under the 1920 Act, challenging that, raising it, would not be open to the defendant.
Well, as it happens, the judge here did investigate the jurisdiction of the Singapore court.
Yes. Yes.
And found that there was jurisdiction, but I suppose you say that's...
Well,
by
that's
the by.
that's what happened in this case, and I'm not disputing that.
But the Cayman Islands court would only produce a binding result if you are subject to its jurisdiction or submitted to its jurisdiction, which, for the purposes of this appeal, you did.
And the fact that in this case, because we're dealing with a question of principle here, we're obviously we're dealing with the question of what the 1920 Act extends to. The fact that in this case the judge was able to find that we had submitted to the Singapore court jurisdiction is neither here nor there. One's got to envisage and allow for circumstances in which the defendant in the English proceedings is in a good position to challenge what happened in the real original court, and so on.
But
it's a question of principle.
Could do so under the 1920 Act.
Couldn't do so under
Could
the
do so. Could do so.
Couldn't do.
Could. Well, that's what the judge here did.
Well, it so happened that she did it.
Because your side submitted, presumably, that the court should exercise its discretion not to enforce the Cayman judgment for that reason.
Well, that was one of the reasons that was submitted, that it was submitted, that the court should not exercise its discretion.
But I mean, I think the only point I'm trying to make is that the result that you foresee doesn't actually arise under the 1920 Act because of the existence of the discretion, and no doubt the just and convenient.
Well, it may or may not arise. It depends how much weight one is going to let the discretion provision actually carry. I mean, if one's looking at the discretion provision, for example, on our facts, yes, it's there, but before you even get into the question of discretion we submit, you have to determine that this is a judgment from an original court within the meaning of the Act itself. I mean, the point is this.
I think we're going round in circles.
Well, we may be. We may be. I do need.
What about the possible? If the Cayman Island court has got it totally wrong, you could appeal the Cayman decision, couldn't you? That would involve a submission, of course.
Well, on that footing, we had already submitted. Yes, we could appeal the.
Yeah. So isn't that the obvious sort of control mechanism in relation to the Cayman court getting it wrong?
Well, not really, my lord, because we might still be in a position to say that the appeal court got it wrong.
Well, that would be the Privy Council ultimately, wouldn't it?
Well, or the Privy Council got it wrong.
But I mean, that's the whole context of this, isn't it? This 1920 Act applied to British dominions, and the ultimate court of appeal for the dominions was the Privy Council. It was according to dominion courts, the empire, if you like, a special status, in one sense, like that which exists within the EU, that you are trusting the courts of the dominions, precisely because they are dominions, and because although they operated different systems of law, they were ultimately subject to a single jurisdiction, or single court of appeal.
Well, that's not a factor. That's certainly correct. It's not a factor that one sees coming into the analysis and considerations that inform either the Sumner Committee or or
They may have been too obvious to need to be spelt out.
well, precisely, I suppose, and it may also have been so obvious that it didn't need to be spelt out, that because the common law didn't allow a judgment on a judgment, that didn't need to be spelt out either.
Correct. So the point is, why in 1920 did Parliament, if you like, change the common law as regards Dominion courts?
Because of, I mean, it was a practical step. We'll see when we look at the
And because
some
they
of the
were
reporting.
Dominion courts.
Well,
I mean, it can't be coincidence, can it, that the 1920 Act applies to Dominion courts?
well, what was being pressed on the committee was that a regime should be put in place to cover all foreign judgments.
Right.
And what they did was adopt what they call a tentative trial of principle,
Right.
to deal simply with the imperial
Yes. All right.
possessions. We'll
I
look
see.
at that
We'll see that. Okay.
in a moment.
Yes.
But I should move on. The other case I wanted to just draw your lordship's attention to is a Canadian case that's behind divider 13 called Cortez. It's a decision of the Supreme Court of British Columbia, and in brief, the facts were that in February 1999, there was an action in the courts of Ecuador in which the plaintiff obtained a judgment against the defendant, but the writ hadn't been served, the order hadn't been served, and only 3 days were allowed for an appeal. In September 1999, the defendant was served in Vancouver, and an action was brought in British Columbia to enforce the Ecuadorian judgment. And in 2004, the Ecuadorian judgment was registered in the state of Illinois, but the Illinois court quashed the registration, and the defendant in British Columbia applied for the dismissal of the British Columbia action. On the first argument was that an issue estoppel had been created by the Illinois proceedings, and we see that set out in the head note. And the court held, this is page 741, the Illinois proceedings did not create an issue estoppel or attack the doctrine of abuse of process. While the parties were the same in both actions, the element of finality was not satisfied. The Illinois action was not simply a civil cause of action, but an action to enforce a judgment. And a party who has the benefit of a judgment in its favour is entitled to try to enforce that judgment in such jurisdictions as it chooses. Nor were the issues the same in the two actions. The Illinois court determined that the Ecuadorian judgment failed to comply with due process. However, it was for the British Columbia court to determine whether the judgment complied with Canadian standards of natural justice. And then, if one looks at the judgment, page 743, paragraph 3, this was the defendant's argument that an unsuccessful attempt by the plaintiff to enforce the judgment in Illinois renders the issue of the judgment's enforceability here res judicata. In the alternative, it argues that the judgment is unenforceable because it was obtained through fraud perpetrated on the Ecuadorian court, and so on. These allegations both arise from lack of actual notice of the proceedings. And then if we turn to page 25 to 27, we simply see the facts as I've summarised them.
Sorry, pages, paragraphs, yes.
Paragraphs 25 to 27.
Yeah.
And then if one moves on to, yes, paragraph 36 is just a description of the argument. And then under finality, at 46 to 49, and then there's reference to the principle of issue estoppel, and the judge goes on, however, different considerations apply to an action to enforce a judgment. A party who has the benefit of a judgment in its favour is entitled to multiple bites at the cherry. It's entitled to attempt to enforce that judgment in any and all jurisdictions until it is paid in full. In my view, an action to enforce a judgment is not meant to be final except in the jurisdiction in which the enforcement action was brought. The issue in front of the Illinois courts was whether the judgment was enforceable in Illinois, not whether it was enforceable in other countries. I conclude that the necessary element of finality is lacking in this case. And
So this was an action to enforce or registration to enforce the original Ecuadorian judgment,
yes,
in which they relied on the enforcement
As a-
in Illinois.
yes.
Yeah. Okay.
that's it. And we say that's a statement of the general common law position applicable in Canada as here, and we say finality is lacking in the present case essentially for the same reason. Now, there's a decision called Clark and Fennoscandia, which I'm not going to take you to now. I'm conscious of the time. It is important that we move on to what Professor Briggs has to say on these subjects, and if I've got time, I will take you back to the Fennoscandia decision. But if we go then, please, to the second authorities bundle at tab 22. And first, well, for the court's notes, 745, just by way of general background and a characteristically combative comment from Professor Briggs at the start of 745 with reference to his own headings. As cumbersome headings go, this one is a serious contender for an unwanted prize. And then he introduces the whole subject, saying...
Sorry, did you say 745?
7.45.
Oh, 0.45.
I'm so sorry.
I was looking at page number.
Page 690. It's my fault.
Thank you. Yep.
7.45 is just the general introduction, and what he says is he's going to deal with the common law position first. And at the top of page 691, we see what he says. The grounds on which a judgment debtor may apply to have registration of the judgment set aside are closely derived from the common law rules relating to foreign judgments. And for this reason, really only for this reason, it makes sense to deal with the common law first. And then he says, well, in one respect, it's the very opposite. But we needn't be concerned with that for present purposes. And then at 747, the judgment in personam will be recognised as binding on and against the party against whom it was given only if it was delivered by a court, which according to English private international law was competent to deliver a judgment which has this effect in England. This requirement pays no attention to the judicial jurisdictional rules of the foreign court or to whether they were complied with. And then if we go right on, please, what then Professor Briggs does at some length is deal with the ways in which the jurisdictional competence of the foreign court can be established. And if we then go right on, please, to 764 at page 718. And there he embarks, second main paragraph, on consideration of the defences to the plea of res judicata, and says that the first is that the judgment was not final and conclusive on the issue in respect of which its recognition is sought. And then there's this important passage at page 721, 766. This is of some importance because the only passage that was cited to the judge below was 786. And we'll come on to that in a moment. And the judge said, well, Professor Briggs doesn't really explain what he meant in 7.86. It becomes much clearer at 766. Defence to recognition, foreign judgment not finally conclusive on the merits, interlocutory judgments and default judgments.
Sorry, where are we again?
Page 721.
721, thank you. Yeah.
In order to be recognised as res judicata, a judgment must be final and conclusive and must be a judgment upon the merits of the action. This means that the foreign court has given a judgment which is not provisional, which makes the matter res judicata in that court. It is the court's last and final word on the issue in question. If to contest the issues in the forest jurisdiction is to appeal to a higher court, judgment appeal against will count as final and conclusive.
Why doesn't the Cayman Islands judgment satisfy that test? It is a judgment on the merits of the question whether the Singapore judgment gives rise to a binding obligation to pay the sum
Cayman.
awarded. No, it doesn't say that. It is not provisional, and it makes the matter res judicator in the Cayman Islands. It's the court's last and final word on the subject. Doesn't that read on precisely to what?
Well, we say that when one talks about final and conclusive on the merits, and all the authorities do, on the merits mean the underlying merits of the claim. And we'll see in our submission at any rate that, in other words, what one's only concerned with when one looks at the Act is what I've called the original court and the original judgment, which has declared in some way on the merits of the original claim.
Well, it may be that that's what the cases are talking about, but isn't that just because this question has not arisen before? And once you factor in the fact that a judgment by a court of competent jurisdiction gives rise to a binding obligation, the theory which underpins an action on a judgment, why can't that itself be a question on the merits of a claim?
Well, it's on the merits. On the merits, we submit in this context means on the merits of the. I quite see as how one gets to Mr. Reza's position, if you like, as a matter of language. But looking at the common law background and looking at the principles and the way in which they're applied and incorporated in the statutes, both the 1920 and the 1933 Act, we say it's evident that what the court was concerned with is simply a two-stage, two-court process in which the first court is, the original court is that which issued the original judgment. And we do come back to the point that on my friend's approach, what is excluded from consideration is the circumstances in which the original judgment was entered in the original court. And that can't be what Parliament intended.
Yeah. Okay.
And I was taking you to what Professor Briggs says, and he gets to the point your Lordship is raising towards the end of that paragraph. He says, if by contrast the judgment can be reopened and reconsidered in the same court, it cannot be said to be final and conclusive, and it cannot be recognised as res judicata at common law. It also means that a judicial decision that a foreign judgment meets the criteria for recognition does not itself count as a judgment. And then he cites the civil law principle. And then in note 534, he says, a decision by the courts of country B that a judgment obtained in country A is enforceable in country B does not make the issue whether the judgment is enforceable in Canada, and one would suppose in England, res judicata as the ruling in country B is not on the merits of the same issue as that which arises in country C. And he cites Cortez, the case we've just looked at, and he says, for a very surprising suggestion, that an order registering a foreign judgment in Singapore is itself capable of registration of a Singapore judgment in Hong Kong, see Morgan Stanley and Pilot Lead or Lead Investments, and that's a case that my friend relies on that no doubt he'll take you to. One supposes...
I'm sorry to interrupt, is the analysis different if what's at issue is an action on a foreign judgment rather than steps to enforce as registration of a foreign judgment?
Well, no, in our respectful submission.
Why not?
Because the principle remains that what you're not obtaining in the foreign jurisdiction is a judgment on the merits, as that is properly to be understood. All you're doing is obtaining a recognition which you can turn into a judgment by way of common law action in the intermediate court. And that's what, so it appears, Professor Briggs, the position Professor Briggs is addressing here. It's certainly the position that Dicey in that 14122 passage that we were looking at was addressing, without distinction between the a registration case and a judgment by way of common law action.
If you look at what the claimants actually got in the Cayman Islands, they didn't get a decision that the judgment was going to be registered. It wasn't a registration case.
No.
They didn't get a ruling that it was enforceable in the Cayman Islands. They got a judgment saying you must pay.
Yes, they did.
Well, why then doesn't my lady's question arise?
Because the same principle applies. It is a matter at common law, as we say, is essential background to the 1920 Act and for that matter the 1933 Act. At common law, a judgment on a judgment, whether it resulted from registration in the foreign jurisdiction or a common law action, is not a judgment on the merits and is not enforceable at common law in England. And Professor Briggs goes on to pursue that at page 723. And he's clearly, when he's talking about on the merits, is clearly what he means by on the merits is that the merits as they stood so far as the original judgment is concerned. The judgment will be conclusive if none of the defences to its recognition may be raised by the party against whom it is asserted. The judgment is on the merits if it is a decision which establishes certain facts proved or not in dispute, states what are the relevant principles of law applicable to such facts, and expresses a conclusion with regard to the effect of applying those principles to the factual situation concerned. If there is judgment for a party on procedural grounds, properly so called, the judgment may not be on the merits. And when you read that with what he said in 766 and his footnote 534, he's plainly talking about the merits so far as they existed with regard to the original judgment. And then very briefly looking at other passages in Briggs.
Are all these cases in the context of an attempt to enforce, let's say in this country, an order or judgment in the originating court where the action on the merits is going on? So they're concerned with distinguishing between effectively final and interlocutory orders.
Well, they may be, my lord.
I mean, that's the context in
That's
which
the context.
this discussion has arisen.
Yes. The principle seems, in the first place, the principle as expressed by the commentators seems to be wider than that.
Well, they go on. I can see that they go on to express the view that you can't enforce a judgment.
And secondly, and I'll have to get into the Act before very long,
Yes.
secondly, the Act itself, we submit, points you firmly in that
Right.
For your Lordship's notes, 785, page 757, and this is the 1920 Act, page 758 perhaps, and what Professor Briggs points out is that the 1920 Act and its criteria for registration very closely derived from the rules of the common law. It is therefore broadly true to say that the statutes identify the countries and affect the procedure and mechanism for recognition and enforcement of judgments to which they extend, but reflect the common law upon the circumstances in or conditions under which judgments from those countries are entitled to enforcement under the Act. And then he deals with aspects of the 1920 Act, and this is the passage that was cited to Her Ladyship below. Section 9 is cited, and then all that Professor Briggs says there, but we know what he says as to the common law position because we've just seen it. It is not said that it excludes a judgment on a foreign judgment, though it seems reasonable to suppose that it does.
Sorry, I know I've seen that, but where are you reading that from?
Sorry, I'm reading that from 786 on page 758, 7.86.
Oh yes, thank you. Yes.
Last sentence, it is not said.
Yeah, I'm there now, thank you.
And then 761, at 7.90, he's moving on to the 1933 Act, and again points out, which is correct, that the 1933 Act, provisions of which also largely reflect the common law, applies to the enforcement and to the recognition of judgments in countries with which a bilateral treaty is concluded, which in accordance with the Act has been enacted into domestic law. Now, I am conscious of the time and I haven't got onto my basic submissions yet, and it's important we should look at the Greer and Sumner Committee reports. I'm going to give your lordships, please, for your lordships note, the passages in Patchett that we rely on. Patchett is behind divider 24, and we rely on the particular passages at 227.
These paragraph numbers.
These are paragraph numbers,
Yeah.
2.27, 3.12, 3.16 and 3.35. And then there's an entire article...
The last one was 3.35.
3.35.
Thank you.
They're all sidelined.
Thank you.
And then there's an entire article by a Professor Smart who addresses what he says was the erroneous decision in the Morgan Stanley case, which no doubt we'll hear more about from my friend in due course. That's at tab 11. And we rely on everything, in fact, that Professor Smart says in that article and his reasoning. It's the reasoning that we bring to bear in the present case.
Did you say tab? What tab did you say that was?
Tab...
Oh, the judgment is it? The Morgan Stanley is tab.
The Morgan Stanley judgment is at tab 11. The Smart article is at
25.
tab 25.
Thank you.
And from there, my lords, my lady, I should take you to the background of the legislation on which both sides place a certain amount of reliance. First, we have behind tab 26 the Sumner report. And what this considers, among other things, is the establishment of a new system for enforcement of judgments first obtained in the, quotes, empire, and then, that's at page 6 at the top of the page, starting at paragraph 24, and there's then a detailed review of what the prison position then was, so far as various dominions are concerned. And then at page 11, at the bottom of the page, paragraph 36, enforcement of what are called foreign judgments. In other words, judgments from countries not within the empire. There's nothing in here, one way or the other, about judgments on judgments. But it is evident from a general review of this, and it's true to say that there's no particular relevant reference that I've seen to the common law position as such. We see more of that when we get to the Greer Committee report. But it's clearly, the conditions which are imposed are clearly derived from the common law principles. There has to be jurisdiction, or there has to be a submission, or it's not to be contrary to public policy, and so on and so forth. And what appears under the enforcement of foreign judgments section from paragraph 36 following, what they're then dealing with is a proposal and a wish on the part of the commercial community then and there to extend the registration system to non-imperial countries, to foreign countries generally. And they decline to do so at this stage. And one of the reasons they decline to do so if one sees this at paragraph 42, is because they regard the system they're setting in place for the empire as essentially a trial run. That's paragraph 42 on page 12. And that reflects what they have already said at paragraph 31. And there's obviously been a certain amount of debate and criticism of their proposals. And they regard what they suggest should be put in place by way of the draft bill as a tentative trial of principle. They say, much as we desire the passing of an Imperial Judgments Extension Act, we think it is of importance to proceed somewhat tentatively in the first instance. If the principle is tried in a limited form and after experience of its working finds general acceptance, amendment and extension are not difficult.
Sorry, where are you reading?
I'm reading from paragraph 31 on page 11, on page 10. So it's a tentative trial of principle, and we say that is relevant because it is unlikely that, assuming the common law rule is as we say it was, no judgment on a judgment, it's unlikely that the committee and later Parliament would be doing something as radical as allowing something in which the common law had not allowed in. The Sumner
I suppose
report.
you could also say that if the 1920 Act were to be read as applying to a judgment on a judgment, then there is nothing in the Act to distinguish between cases where the original judgment is from a court within the empire and those where it is not.
That is true, because what you would be, if you'd succeeded in importing your non-imperial judgment, as it were, into a state, into a country within the empire.
I mean, the American judgment would have to get enforced somewhere within the empire
Yes.
first.
Well, that is that is exactly the problem, of course, that was being identified by the by the Advocate General in the Owens and Bracco case, and is the essence of the point that underlies what has been repeatedly said to be the undesirability of allowing judgments on judgment, because it allows you to leapfrog.
Yes. Right.
The Sumner Committee report deserves a bit more attention. I'm sorry, the Greer Committee report, which preceded the passing of the 1933 Act, and it deserves particular attention because it has quite a lot to say about the 1920 Act. But moving as swiftly as I can through it.
So that's where
That's behind divider 27.
right.
And it starts by explaining why the legislation is necessary. It's because English judgment creditors are having difficulty enforcing judgments in foreign countries because, in particular, the principles on which English courts accept foreign judgments as conclusive depends on case law and are not to be found formulated in the statute book. That's little 2 towards the bottom of page 5. And then there's this important passage, top of page 6. So far as the position in England is concerned, the change suggested by the committee is one of procedure rather than of substance and involves no radical alterations of the present position. And though the existing procedure by action on a foreign judgment will, under our recommendations, be replaced by a system under which the foreign judgments will be registered and enforced as if they were judgments of an English court, the defendant in this country will be able to resist registration on substantially the same grounds as those on which he can now maintain that a foreign judgment, i.e. by reference to the common law rules. And then, if one looks then, well, there's reference to basic principles in paragraphs 4 and 5, and then goes, please, to paragraph 10b on page 11. The whole of the English procedure, including the conditions required for the recognition of a foreign judgment as conclusive, depends upon rules of common law only. There's always a natural tendency for the foreign court to suppose that such common law rules are too indefinite to be applied as rigidly as the provisions of a statute or code, and that they are largely discretionary, and so on. And that accounts for the reasons that there was no discretion in the 1933 Act. And then there's this interesting paragraph 11, which shows that to some extent the system that was adopted by the 1933 Act was designed to mirror or reflect the exequatur provision on the continent. There are in existence a large number of conventions between European and foreign countries providing for the reciprocal enforcement of judgments in civil and commercial matters, under which judgments given in one country are recognised as final and conclusive in the other and enforced by the grant of an exequatur. A study of these conventions shows, however, that these obligations are generally only undertaken in respect of judgments which fulfil certain conditions, and it is for the courts of the country where the foreign judgment is relied upon to determine whether those conditions are fulfilled before it enforces the judgment. These conditions appear, speaking generally, to be reasonably similar to the conditions required under English common law if a foreign judgment is to be recognised as conclusive or to be made the subject of a successful action upon the judgment. So what evidently the committee is recommending is a series of more certain provisions not affected by a discretion or something of that sort, which will encourage reciprocity so far as foreign courts are concerned. And then paragraph 13, please. Now, perhaps we can pass over that. Paragraph 18, please, on page 17. And the committee says, the present committee, a few lines down from the top, in its work has been guided by the following principles, with respect to which it found itself in full agreement with the preliminary committee of 1929. The object in view is to secure the recognition and enforcement of English judgments in foreign countries. 2, in the arrangements to be made in return for reciprocal treatment for the recognition and enforcement in the United Kingdom of the judgments of foreign countries, the existing principles of the common law should be followed in matters of substance, and in matters of procedure, the procedure adopted in the Administration of Justice Act 1920 in the case of the judgments of countries within the British Empire. Nevertheless, while no substantial departure from general principle number 2 should be admitted, it will be worthwhile to make such minor alterations as might prove to be necessary to obtain agreement with foreign countries for the conclusion of satisfactory conventions if such alterations are reasonable. And that's something of a snapshot of some of what the Greer Committee was saying about the existing common law. Again, like the Sumner Committee, like the 1920 Act, it doesn't specifically address the question of judgments on judgments. But it is very firm in pointing out that the registration regimes reflect the common law. And it's the case that neither the 1920 Act nor the 1933 Act were, except in what are referred to as minor areas, minor alterations, concerned with the substance of the underlying rules, concerned with the substance of the common law rules. What they were primarily concerned with was setting up an efficient procedure, which, particularly in the case of the 1933 Act, was one that would be, if you like, convincing, one that would promote reciprocity so far as foreign courts and foreign countries were concerned.
But they did spell out the common law rules. Both acts do, don't they?
Both acts, we're going to look at the acts, at the acts now.
But I mean, when they say that the existing principles of the common law should be followed in matters of substance, the Act does that.
Well, the Act
It doesn't just incorporate the common law, it spells out what it's referring to.
Absolutely not. It doesn't say...
No, it doesn't incorporate by reference the common law rules, it just...
Yes,
Yes.
that's the point. So from there, can we please turn to the Act itself, which is in Bundle 1, behind Divider 1. And what I'm turning to now is, and well, we can look at the general structure of Part 2 of the Act first. 9.1 contains the general provision with which the court will be familiar by now. And then 9.2 provides that no judgment shall be ordered to be registered under this section if, and then there's a series of common law derived situations in which the judgment will not be registered. And then there are some, if you like, administrative aspects and reference to the making of rules of court. And then there's this at 5, which I will come back to. In any action brought in any court in the United Kingdom on any judgment which might be ordered to be registered under this section, plaintiff shall not be entitled to recover any costs of the action unless an application to register the judgment under this section has previously been refused or unless the court otherwise orders. And then there's 2 definitions in section 12. In this part of this Act, unless the context otherwise requires, the expression judgment means any judgment or order given or made by a court in any civil proceedings, whether before or after the passing of this Act, whereby any sum of money is made payable. And then this is important, and I'll again come back to this a bit later, and includes an award in proceedings on an arbitration if the award has, in pursuance of the law in force in the place where it was made, become enforceable in the same manner as a judgment given by a court in that place. And then the expression original court in relation to any judgment means the court by which the judgment was given. Now, as I say, I want to draw attention to 1 or 2 of those specific provisions, but I want to put it in the context of my general series of submissions as to why it is that we say that the 1920 Act does not extend to judgments on judgments. The first point is that the 1920 Act was intended by Parliament to substantially reproduce the common law. What was new, and effectively only new, was the mechanism, was the registration process. And I say that really for 4 reasons. One, we can see that that's what it in fact did. It reproduced the common law objections to enforcement in England. Secondly, 12 years later, the Greer Committee regarded it as having done so and based the 1933 Act on the same principles. Thirdly, and I don't think I have time to turn it up, but we've seen reference to it in the passage from Benyon, the Oeds Bank and Bracco case in the House of Lords, acknowledges the common law basis for the 1920 Act, and we submit that all academic commentary, and I've taken you to a good deal of it, is to the same effect. Secondly, there is no suggestion anywhere in any of the commentators or any of the material that we have seen that the jurisdiction the substantive jurisdiction to allow the enforcement of foreign judgments was expanded by the 1920 Act or the 1933 Act. That is, in making enforceable judgments which had not previously been enforceable. The third point is a point that we have discussed already. We submit that at common law, judgments on judgments were not enforceable by action, primarily because, for the reasons that Professor Briggs gives, they are not judgments on the merits. And as I say, the respondent, Mr. Reza, does not appear to dispute that at common law, judgments on judgments are not enforceable by action. Fourth, the 1920 and 1933 Acts were, we submit on the material available to the court, intended to achieve the same outcome by broadly the same procedure. And what we see the 1933 Act doing is it's building on the 1920 Act, as in fact the 1920 Act had looked forward to in the light of experience. And as the Greer Committee expresses it, the 1933 Act was intended to reproduce the common law with minor changes.
I mean, that sounds like a repeat of your first point, but maybe wrong.
It is effectively, yes.
Right, okay.
Fifth, and I've made this point already, looking at the universe of systems and schemes for the enforcement of foreign judgments here, the 1920 Act is an outlier. It's out of step with all the other regimes. Now, it's not very easy to account for the 1982 change and why that was confined to the 1933 Act alone. I suppose it may have been something to do with the fact, and I know Mr. Reza is going to address you on this, it may have been something to do with the fact that, of course, countries who were parties to conventions under the 1933 Act were also members of the European Union, or at that stage, the European Community. Whether that can account for it, I don't know, but that may of itself have led to specific focus on it. What can't be said, we submit, is that there is, assuming that the common law is as we always said it was, as we say it always was, and assuming that the Act is intended to reproduce, the 1933 Act was intended to reproduce the common law, we say, as I said to my Lord Justice Richards earlier, we say it's confirmatory, not altering the law. Moving to the words used in the Act itself, and this is our sixth point, the term any judgment given or made by a court in any civil proceedings, that phrase taken alone is very wide. It's not so wide and becomes at best, at least ambiguous, when you read it with the term original court. As I say, any judgment is capable, as a matter of language, of catching the Cayman Islands judgment, but original court, we submit, is strongly suggestive, put at its lowest, of the court which gave the original judgment. And really, there is on that footing a tension, assuming with me that original court is strongly suggestive of the court which gave the original judgment. Should the reference to any judgment, as it were, drag original court away from its natural meaning, so that it means no more than the court which gave the intermediate judgment? Or does the dragging, if you like, go on all in the other direction with a literal meaning of any judgment, qualifying the natural meaning of original court?
Original court is itself a defined term.
Yes, it's defined as the court by which the judgment was given. But read with the term judgment, it begs the question, when you talk about where the judgment was given, it begs the question, because original court, more naturally at any rate we submit, means what we call the true original court, it begs the whole question as to what any judgment and original court actually means.
Yeah, it's as a principle of construction, you can look to the defined term to get a sense as to what was being identified. I mean, in one sense, you could say a defined term is just an empty vessel that you pour meaning into, so it can mean anything. But you say, and there are authorities on this, that actually the words used as the definition can have some influence on what is meant.
Yes.
Yes,
but from there,
that's what you get.
Yeah, from there, I wanted to draw attention to 4 particular features of the 1920 Act. The first is a point I've made already, that the Act is evidently concerned only with 2 courts and 2 stages. What is called the judgment in the original court and that in the registering court.
But how much does that tell us, for example, in the case where the creditor has brought an action on the judgment in a Dominion country?
What it tells you is this, and it's really a point by let me put it this way. What it makes anomalous, if Mr. Reza is right, what it makes anomalous is the fact that on that footing, the English court is not required to consider, under the Act, the circumstances in which the original judgment, the Singapore judgment, was obtained. When the essence of, at any rate, the origins of this provision and its general application is the ability of the defendant to be able to say to the English court, the original judgment.
But it is obliged to consider the circumstances in which the Cayman judgment was obtained.
Yes. But the Cayman... Let me put it this way. What it can't do, first point is that what the English court can't do is question the merits of the Cayman Island judgment. It's restricted in terms of the objections that can be made to registration of the Cayman Island judgment.
So you're quite right, actually. I mean, you're quite right, I think, so far as Section 9.2 is concerned. But there is still a discretion.
There is still a discretion. That's true. There is still a discretion. But if you like, the primary force of and the reproduction of the common law rules that we see are clear and strict. And it remains anomalous in our submission that somehow you've got to fall back on the discretion when one would expect it to have been in the forefront of Parliament's mind that these provisions should apply should apply to any judgment, if you like, in the chain. And because only 2 are being referred to, and only 2 stages are being referred to, that makes it all the more likely that what Parliament had in mind here was only the true original court and original judgment and the registering court.
Yeah.
But only 2 stages are envisaged because that's as it were the template. You have a judgment from the Dominion Court, and that's the original court. See the 2 linked definitions in section 12.1, and then that judgment is registered by the court.
You have to then ask yourself the question: well, why on earth would Parliament have excluded consideration of what I call the original judgment, merely because it had been if you like, transmitted, or it had been used to obtain a judgment, or for that matter, a registration in another foreign jurisdiction. Why should it have excluded that? Why should Parliament have put so much faith in the intermediate court?
Well, because
Because
that
it's
goes.
a court of a dominion.
Yes, it goes back to what I was saying earlier, that this is a sort of mutual recognition system, if you like, created by statute for dominion courts.
Well, that's undoubtedly true, but that of itself does not explain why you should be barred from challenging, which you would be, challenging the judgment of the original court, which could be in another, with the greatest respect to such places, a small island with an undeveloped.
Well, indeed, but we've
jurisdiction or
gone
anything
over
of
it
that sort.
slightly because it's got a system of appeals which ended up in Downing Street.
Well, they may do, but an awful lot has got to happen before one gets from a first instance decision in a Caribbean or Pacific island
That's true.
to the Privy Council. And the idea that the Parliament should have been happy or should not have been concerned to exclude consideration of circumstances in which the original judgment was obtained because it might be corrected in due course by the Privy Council.
All right. I mean, there are two things. There's that, and you say, well, that we shouldn't attach really much weight. It's not really conceivable that Parliament attached weight to that. And the second is the safety valve of the discretion in Section 9.1.
But that's putting an awful lot of... In the first place, we say about that, well, before you even get there, you've got to work out what the defined terms in fact extend to.
Of course.
Judgment.
Oh, yes, I understand.
But also, it's putting a huge amount of weight on the exercise of a discretion, and also in a fundamental area. The difference between allowing judgments on judgments and not doing so, given the undesirability that some people have commented on, is potentially fundamental. So that it would be pretty odd if Parliament had left that distinction, that difference, merely to an exercise of discretion.
All right. So I'm sorry, we're not just you had four particular features of the 1920
Yes.
Act. The first is the two courts and two
The
stages.
first was two courts and two stages.
Yes.
Secondly, although one can see that it's not conclusive in itself, Section 9.3a itself, the judgment shall, as from the date of registration, be of the same force and effect, and proceedings may be taken thereon as if it had been a judgment originally obtained or entered up on the date of registration in the registering court. And we simply say that although it is capable of both meanings, both interpretations that we and the respondent seek to attach to it, as a matter of common sense, natural and ordinary meaning, is that what is being said here is that it becomes in England the equivalent of the original substantive judgment. And the third point we draw attention to is the provision for arbitration in the definition of judgment. We looked at this earlier. In the definition of judgment, it includes arbitration awards if the arbitration award has become enforceable as a judgment under the law in the place where it was made, and the award becomes enforceable in the same manner as a judgment given by a court in that place. And that, we suggest, can only be concerned with a single judgment or other step taken in the seat of the arbitration. And that points to, at any rate, the arbitration aspect of the definition of judgment being concerned only with the original what we've called the original court.
But, I mean, was there any common law basis for obtaining judgments on a foreign arbitration or award?
I will have to look at that over.
Because I'm just trying to think, I mean, I can't otherwise see how this would come in. I mean, it clearly extends the definition of judgment.
Yes.
But all I was wondering is, well, supposing you were seeking to enforce a judgment on an arbitration award, sort of analogous to our case, as it were, I don't think it probably works, does it, at that stage? I'm not sure. But so the question might arise, supposing you get an arbitration award in Singapore, you obtain a judgment on that award in the Cayman Islands, could you then enforce that could you then enforce, under this Act, the Cayman Island judgment here? But I'm not quite sure
it's
how
very
far
unlikely
that would
to
work.
arise. You could get
Well, that's what I was thinking, yes.
You could get your judgment
Anyway,
on the
your
award
point-
in Singapore,
Yes.
but
yes.
but I don't think anybody would suggest you could get a judgment on the award,
an award.
and that then becomes exportable.
Has, in pursuance, become enforceable as the same manner as a judgment. I see. Yes. Anyway, I mean, I see the point you're making.
And the last point before we adjourn, I'll talk to your lordships about progress in a moment.
Yes.
It's subsection 5 of section 9, the provision that deals with the costs not being recoverable if you proceed at common law when you could have proceeded by registration. And we submit that the premise of that must be that the judgment creditor can achieve all he could have achieved by a common law action by means of registration. And so you're wasting money, and you shouldn't have the costs if you proceed by common law action when you could proceed by way of registration.
I see.
And that, we submit, helps to align the substance of the common law and the Act itself.
Right.
So that goes back to the question whether the common law would have permitted this.
Yes.
And you say, well, you've got the academic commentary and so on, but there isn't, you can't point to a decision of common law.
I can't point to a specific decision. Nuvian, we submit, comes close to it. Cortes comes close to it. But it is odd that there's no, it's certainly odd that here we are in 2020 and there's no specific authority that we can point to that effect.
Right, so, sorry.
Yeah, sorry.
Carry on.
I was going to say, if there's no common law authority that deals with the point, and Parliament wasn't thinking about the point when this was enacted, aren't we just left with the language of the Act?
You're left with the language of the Act against its common law background. And one's left also with the cogitations of academics and Lord Justice Greer's committee and everything else on that, on related subjects, if not that specific subject since.
Yeah.
Now, I will move on as fast as I can after lunch.
Well, what? I mean, almost looking back at what you told us you were going to be addressing, it seemed to me you'd come to the end. But, you were going to summarise your main submissions on the 1920 Act, which you've really just done, haven't you?
No, I've done that.
So what's
There's
that?
one or two points I want to make about the anomalies to which Mr. Reza's position gives rise, and then I can leave this until I've heard from him. I've got a series of points about what I see in his
Wouldn't it be better to deal with his submissions after you've heard?
It would be. So I can be
All right.
no more than 5 or 10 minutes.
Doing what?
My last point on anomalies.
Well, they're his anomalies, aren't they?
Now, I'm pointing out the anomalies that his construction
All right,
creates.
do that. All right, so I hope you can get that done in 5 minutes.
I will do.
Thank you, Mr. Ronso. Very good, 2 o'clock.
All rise.